three of you can get together, call a meeting, have a notary public, sign a warrant, send the warrant out to everybody 30 days in advance, have a meeting, elect a road commissioner, choose a budget, choose what your fair and equitable assessments are for all the lot owners, send out the minutes of the meeting to everybody within 30 days, and you're good to go. And you have enforcement teeth if you do it right. You can collect from people either by going to court or by filing a notice of claim with the registry of deeds. Yes.
When you set that up like that, are you required to fill out?
No, we're not allowed to use the word lien because that's the word everybody knows. What it actually is, what's allowed in the law is if you form a statutory road association and you do it right, cross all your T's and dot all your I's and hold your meeting correctly, if someone doesn't pay their annual assessment and they're 90 days delinquent, you can then send them a 30-day notice saying you got 30 days to pay your dues or we're going to file a notice in the registry of deeds. If they still don't pay, you can file what's called a notice of claim. Acts like a lien, looks like a lien, just don't call it a lien. It's a notice of claim in the registry of deeds against that property owner for that year's assessment. And it sits there. And eventually, you get paid. It's kind of amazing. Either they go to refinance, and it gets paid. Or they go to sell, and it gets paid. Or they die, and someone inherits it, and you get paid. So it's actually a pretty effective, slightly passive-aggressive, but fairly effective tool to collect from your neighbors without having to go straight to court. And what the legislature did this year is they amended just that provision of the law. It was put out by the main realtors. Main realtors were very concerned that statutory road associations are kind of not a creature anybody recognizes, and they only exist from year to year, and so what are they really, and what if there's a lien out there from a statutory road association, and we can't figure out who to pay and how to get it discharged. It's a cloud on the title, and it's going to keep us from selling this real estate. So the realtors got together and proposed this law that said any notice of claim that gets filed with the registry of deeds has an expiration date built into it now, 18 months. What you can do 17 months and 29 days after you've recorded your notice of claim is file a notice of extension. And that's good for another 18 months. So it's a little bit more paperwork, it's a little bit more burden on your treasurer or your secretary or your road commissioner or whoever does that work. I handed out the law. I also have, and I'll hand out fresh off the presses because nobody's ever had to draft one of these before, I made up a template for you all for a notice of extension.
Yeah, good.
So if you've worked with me before, and several of you have, or worked with Cliff before, your notice of non-payment is going to look kind of similar to this. And what I've done is just modified it to say notice of extension. So what you do is you fill in the name of your treasurer, who you recorded that notice of claim against, and the book and page it was recorded in, the date, because that triggers that 18 months, and so you're making sure that you're getting it in within 18 months to file your extension, what that assessment was for, and interestingly and importantly, that assessment remains unpaid. Because otherwise, if it expires after 18 months, they're going to assume it was paid, or you'll need to revive it all over again. And then the most important thing is I put in contact information. So people who are researching title on property need to know who to call to find out what they owe. So put in your treasurer's name, put in a phone number, something like that, so that people can find you. And then that will need to get notarized, just like the first notice of claim does before it goes to the registry. So we'll hand those out.
So these extensions have to be updated again?
Every 18 months. So if you've got somebody who's perennially delinquent,
So the expiration is what makes it not a lien?
no, the language is what makes it not a lien, because it doesn't say lien in the statute. It
But
says
a
no
lien wouldn't
But a lien, true lien would not expire.
As they accumulate, do they become cumulative claims, or is it an additional claim each time as it adds up?
Great question. Your statutory road association technically only exists for 12-month periods. You have a 12-month budget. You have a 12-month single assessment toward someone. So every single time you file a notice of claim, it's only for that 1 year. And so the question he's saying is, do you have to file this extension on each of those individual ones? I think you can stack them up. I think you could extend a series of them, except that the expiration dates are going to be kind of wonky. So I think it might be easier, a little more expensive, but it might be easier to just keep it more linear. extension for each
Can
one.
you go backwards, so you didn't file the notice 2 years ago, can you now file now?
You
Or
mean-
after the 18 months, can you no longer file?
You mean the first notice of claim?
Yes. So say you let someone go for a year or two, you now file 2 years later? Retroactive?
It's more than 90 days delinquent. You still got to give them 30 days to cure it. You still got to tell them how much they owe. And then if they don't pay, you can then file a notice of claim if you called your meeting correctly in the first place. So make sure you got all your ducks in a row before you even go down that road.
Yeah, what about-
But on the notice of extension, on the retroactivity, this is a little alarming. And so how many of you right now have notices of claim recorded in the registry of deeds against landowners on your road? How old are they?
Older than a year.
Older than 18 months? Anybody?
Yeah.
All right. I consulted with 3 different title attorneys yesterday who were in favor of this law, and I said, does this mean only notices of claim recorded after this law goes into effect around, what did we decide to, early November?
Yes.
Or does this mean any notice of claim that's been reported in the past is going to expire after 18 months? What does that mean? They all said they think this is retroactive. So I'm going to be sending out a massive email, and many of you will get it, saying if you've got some out there that are looking like they're 18 months or older, let's get those extensions filed in early November and try to preserve whatever rights we have, and that'll trigger us going forward. Yes?
So I have some perennial delinquent residents, and each year I send them the 30-day notice, notice of claim, and I stack up what's happened previously. So, okay, you owed 2010, 2011, 2012, 13, 14, 15, 16. It's now summed up here. Here's the interest charges. Here's the filing fees. Here's what you owe looking backwards. And you owe $500 for this year as well. Is that equivalent to an extension? Because I now have a current one that has stacked it all up with interest charges and put it in their face.
Interest is a different question. We'll address that in a second. Does that qualify as a notice of extension without being called a notice of extension?
Yeah.
And
They've been notified
They have been
on an
notified.
annual basis.
But-
he didn't record it.
Oh, so it's never been recorded?
Oh, it's all recorded?
Oh, it's all recorded,
Oh, okay.
yeah. Let's tweak your paperwork, and let's just say, let's add, and this shall serve as a notice of extension for X, Y, and Z. I think you can do it that way.
We have one that only even accepts the registered letter. They know it's from us.
You don't have to send a registered letter. You can send a regular letter.
They do all.
Oh, well.
So then,
Return receipt request comes back denied.
so then, can we then just file it?
Yeah, yeah, absolutely.
But keep the paperwork that
I mean, if you know that you're sending it to the correct address, just like when the town sends the tax bill, you know you're sending it to the correct address, and it's getting kicked back just out of spite, then you've done your best to give them notice, right? You've given notice probably of the meeting the same way. You've done your best. They've had every opportunity to participate, to vote, to be part of the process. I'm going to put the same burden on road associations, though, that towns have, and that is that if they are ready to go to lien on a tax bill, and they send out their required 30-day notices and their tax liens, and it gets kicked back because it is truly undeliverable, and the town knows that no one's living there, you got to make a little extra effort to find it. I would put it that way. But I don't want to take up too much of this on the whole lien thing, because Cliff's presentation, I think, is good. But you raised an issue on interest, and I get dragged through the mud a lot on the website. I'm usually the attorney that everybody's referring to. Interest is a great question, and it's a really muddy area, and I just want to sort of go over my understanding of charging interest if you're a statutory road association. Normally, I mean, it just makes sense. How else are you going to incentivize people to pay their bills on time if you don't have something built in, right? So we all charge interest. It doesn't actually say in the statute that you can do that. So I have always told people, if you want to be conservative, don't charge interest because we don't know if a judge will hold it up in court. If you want to charge interest and it's been working, great. Keep doing it. And I think probably if you have a set of bylaws that builds in interest and everybody's on notice that there's a certain amount of interest, in all likelihood, maybe a judge would look at that and say, well, regardless of whether or not the law allows it, you were on notice of it, that kind of thing. So that is fuzzy territory. I just wanted to sort of point that out. The annoying thing about statutory road associations is how much gray area there is. I know you want us up here to be black and white, but,
If they're gonna charge interest in the notice of claim, you probably should add that as an additional
Separate.
paragraph, as a
Separate.
separate, so everyone gets an actual notice that there is interest running.
What if you're a mixed association, nonprofit, as well as statutory,
Mhm.
and you have bylaws? This issue of interest now, mentioned in bylaws, is going to be enforceable, correct?
I hope so. I mean, that's the thing, there's so little case law that's really tested in statute. That hasn't been tested. So, we
We
just
have
all
late fees and hours.
and
Do
that,
you look at that the same?
it's exactly the same way. It's not mentioned in the statute, and so my only advice to you would be, great, sounds like a good incentive, see if you can make it work. But understand that if you get somebody in your road association who thinks this is communism and is going to take you to court, fight it tooth and nail, it's conceivable that a judge would award the assessment, but perhaps not award you the interest in the late fees. It's a risk, that's all.
But with no downside.
Four owners, there have to be 4 lots benefited by this private roadway bridge. 3 of them can call the meeting. 3 individual owners, not one person owning 3. 3 individual owners, not one person owning 3.
Any profit that you make, any interest that you make to the IRS with the 1099, just like every other person. If the association isn't making any money, it has no profit at the end, it has no taxable income, it doesn't need to file. So yes, you need an EIS in order to associate with the bank. Yes, you're going to get 1099s. Yes, you may need to send out 1099s to your local contractor who you've paid over so many hundreds of dollars to. But I can't imagine a road association making enough profit, and it's a big number. At the end of the year, you end up with this big fat bank account that you have to pay taxes on it. So I want it to be clear that it's my understanding you do not have to file. You do have to have an EIS, which is no big deal.
We do have to file 1099s with contractors?
Yeah, if you pay anybody
Not if
anything.
they're corporations, not if they're incorporated or LLCs, but if you have an individual, you're supposed to pay an EIN, sort of, the whole nanny tax, everybody, if it's a certain amount of money, is it over 600? Yeah, if you pay anybody over 600 supposedly as a professional, and they're not incorporated, you're supposed to send them 1099.
And if they're a sole proprietor, that's
I can see it in my mind. 2017, there's going to be a hurricane move through Maine, and it's going to dump 6.5 inches of water. And you folks are going to go out the next day and find a bunch of culverts washed out. And it ain't in your budget. You don't have the money to replace these culverts. Now, this actually happened. It wasn't a hurricane. It was last spring. A road association road washed out, and they were looking at thousands of dollars. And the little road association I live in, we just had a culvert replaced, and it cost us $6,000 to replace a simple 20-foot culvert. So you can imagine what your problems would be, because you can have an emergency meeting under the statute called for the purposes of raising funds for the emergency. But it's going to take a number of weeks before you get that meeting. And then it's going to take you a number of weeks to get the assessments out and to get the money back in. In the meantime, no one can get across these washouts. And the motel bills are adding up. There is a way around that, and that is in the statute. It talks about road associations, and this is subsection 4A of section 3101. And let me just read it. A road association under this subchapter through its commissioner or board, may address present and future, that's the operative wording, present and future repair and maintenance of private road, private way, or bridge as authorized by the owners of the meeting, at a meeting, called and conducted pursuant to the section, until the association is dissolved by a majority of the voters, of its members. That was passed in 2013, and that was the year that I wrote all the changes for the law that were adopted, including this one. Because I wanted to change part of the orientation of the law to provide for present maintenance, meaning the current year, and future maintenance, meaning sometime out into the future, until the association is actually dissolved by a vote of its members. So I think this changed the statute. So you're no longer a year-to-year road association. You now are one that will continue year to year. You have to do a budget every year. You got to go through the process. You got to have your annual meeting. But you could develop under that section a reserve account. The reserve account could also be spelled out in your bylaws. And so you can have your annual assessment, and a piece of the annual assessment can be a reserve account for emergencies. And as authorized by the members, either by a bylaw amendment or at the time the reserve account is set up, it can include the process whereby that can be appropriated and spent. You could delegate it to the board of directors, the commissioner and officers, or whatever you call it. Or it could say only with a vote of the majority vote of the members can the reserve account be spent. That's the way at a town meeting, when you vote for a reserve account for the fire engine or for road improvements, it takes a vote of the town meeting to release that money. But you could have it authorized by the members that the board of directors could spend the money, because remember you have to act quickly because the road is washed out and people can't get home. So neighbor yelling at neighbor, more attempts to dissolve or set up competing road associations, litigation, and all of which I have experienced and seen and been involved in on one side or the other. And the statute has a couple of important provisions in it. The first is notice of meetings go to all property owners. Voting rights go to all property owners. Assessments do not have to go to all property owners. Keep that in mind. Everyone gets a right to know about the meeting. Everyone has a right to go to vote on the budget at the meeting. But the association does not have to make the assessments on every single property owner. In the statute, it talks about at a meeting, the owners may determine the amount of money to be paid by each owner, blah, 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 blah. The determination of each owner's share of the total cost must be fair and equitable. Those are operative legal terms. Fair and equitable. And based upon a formula provided for in the association bylaws are adopted by the owners at a meeting called and conducted pursuant to this section. So, at the meeting they determine what costs are going to be assessed on how much on each owner. It could be zero. That's a determination. Is the amount for this type of owner is zero. For this type of owner, it is X. Fair and equitable means people similarly situated are similarly assessed. So you can set up classes of owners of different types along the road and assess them equally within their own classification. So, I want to try to illustrate it. Get the highway up here.
What about
Because if someone down here has a second guest house, which they rent out, that would be 2 dwelling units. They would pay 2 assessments. This person would pay a single restaurant assessment because it's only 1 dwelling unit.
But they get 2 votes.
They don't get 2 votes.
They don't.
No.
If you're paying assessment on 2 lots, don't you get 2 votes?
I haven't come to that example yet. We're just dealing with
We're getting there though.
your bylaws on this double lot. Your bylaws could simply say that lots that abut each other are considered 1 lot, with 1 vote. Or it could give 2 per actual lots owned because they both benefit by it. It's up to you. That's one of the variations. There is incredible flexibility mixed in with all of this. Okay, you go down, and this road branches off, and you have a boy and girls camp down here with all the traffic coming and going. And that gets into real volatile controversy at annual meetings. Another reason why you might want to split it up if there's a hill in the middle, when I put the hill in the middle, is because the statute says you can't vote to pave this road and pass the assessments on to the owners, unless it's a hill where you need to have paving for the purposes of stopping erosion. Well, if you're going to pave this hill and it benefits these people and not those people, then that assessment should end up on these people to be fair and equitable.
What about year-round versus seasonal residents?
Yes, that's definitely a difference. A number of road associations have summer maintenance and winter maintenance budget items, and the winter maintenance goes to the people who live there year-round, and the summer maintenance goes to everybody, or with some form of the variation. So yes, you can do it that way. I don't know any road association that does it, but in theory, you could base your assessment on the municipal valuation.
That used to be the law. The old statutory road association law, in existence for, it lasted about maybe a year and a half, I think, in this iteration, tied your actual assessment to the municipal assessment of the property. Complete pain in the neck. I'm glad
Yeah, it would be very difficult, and to administer, it would be a nightmare. It would
And to be honest, I'm not sure it's fair and equitable. If you've got a millionaire who's got some incredibly fancy camp and 1 car, and he never rents it out, and he's hardly ever there, and then you've got somebody who's got, you know, an outbuilding that they turned into a bunkhouse and a little tiny camp, and they're constantly renting it out, and they've got tons of relatives that come all the time, and the traffic they generate is unbelievable. They're paying substantially less than a millionaire, and based on use, maybe it's not fair and equitable. So I don't really like the tax assessment.
No, I would discourage. Specifically now authorizes the cost of liability insurance to be part of the maintenance fee. When I have litigated issues about maintenance in the past, the courts have always said, of course liability insurance is a part of maintenance. Anyone would be an idiot to maintain a road without liability insurance. And so the simple answer is, the people on the road have a daughter that's 24, and she's going out with and about to be married to a Harvard medical student who was doing his internship at Brigham and Young, and it's a rainy night, and they drive in, and he turns over, and he mashes his head, and he's in a coma, and you are going to be, every single one of you, separately, severally, and collectively are going to be responsible for his damages. It's a multi-million-dollar case. And they can get a judgment and take your property from you. Whatever property you own. Property here, wherever. So you are absolutely foolish and stupid if you don't have liability insurance with people driving on your road. Motorcycle. Hits a patch, boom, he goes flying through the woods, smashes his head. Do you want to pay for his medical insurance? Insurance is cheap. The subdivision road that I live on is a half a mile. There are 7 residences. We're all year round. It's in Freeport. We pay $750 a year for $2,500,000 liability policy. And plus, and your homeowners may not cover it. Because if the road association owns the road or someone else owns the road, it's not part of your homeowner's coverage. It may not be. You can't rely upon homeowners. So the answer is yes. When I bought into that property back in '89, I refused to close until the seller set up a road association and showed evidence of insurance. And now some title attorneys are saying, advising banks are advising people the same way. So the other thing is, if you're a volunteer and you say, oh, I'll save you money, I will go out on my tractor and I will grade this road, you are doubly liable because you screwed up. You did such a bad job grading that road that that motorcycle pulverized his head on that pine tree. And so we're going to sue you separately from the Owners Association, and we're going to say the Owners Association negligently authorized you, who didn't know what you were doing, to go out and maintain it, so they're all liable, and you're liable because you were the one on the tractor who screwed it up. So don't go out there and maintain your road like a nice guy. Now, I know some people do that, and they like riding around the tractor with their rake on the back, and then they got a nice crown on it, just like you guys say he's supposed to do. But
So this is a question I came loaded for here, and maybe some people in here can help too, because it has to do with the insurance policy. How many road associations actually own their road? And how many road associations are actually taking care of a road that's owned by a timber company or somebody else? Is it common that you own the road, and how does that affect liability insurance? Because in our case, we're a road association, but our road is privately owned by a timber company, and they don't carry any liability insurance. We carry a liability, and we carry directors and officers insurance on top of that because somebody advised us, and there was a big battle about it. So I want to ask about the directors and officers insurance on top of the liability, as well as what is the difference between a road association that actually owns their road and a road association that maintains a road owned by somebody else, and what is their responsibility? That's 5 questions in one.
yeah,
I'll answer them one of them because it's the easiest. The owner of the road has absolutely no obligation to maintain the road, period. They have an obligation to not obstruct your right-of-way over the road, but they have no obligation whatsoever to maintain that road if it's a private road. So,
and if it's owned by a third party.
right.
If it's a third party, such as the lumber company, they have a right to maintain it for themselves. They have no obligation to maintain it for you. There are a number of scenarios. One, this subdivision was laid out back in 1936 when a lot of shore frontage was sold off. and no one knows who owns the road. It's just out there. And so there is some suggestion in statutes that if you have a property description that goes to the edge of the road, you actually own to the middle of the road. So you may unknowingly own to the middle of the road. Your homeowners would cover that, maybe. So you need insurance. If the road association if the road was laid out in a subdivision, and the developer might very well have created or deeded over to the road association that has set up the ownership of the road. So in that case, the road would be owned by the road association for the benefit of all of the owners. Individual deeds for each property, or some of them, but not all of them, might say they own the road in common with everybody else who happens to have an ownership of a lot that benefits. So it's very difficult to say who owns a road unless there's a very recent history of it being created.
Well, in this case, the road is
Converse of
owned.
that, the result of that is, if there's a statutory road association, insurance companies will sell you an insurance policy even if you don't own the road. If you maintain it, they will give you an insurance policy, and all the insurance policies that I have seen, and certainly our own, is it covers every single owner, it covers the offices, and it covers all the members who are the owners, and the directors. It covers everybody except the person who is actually doing the work.
It's a great deal for the road owner, the owner of the road, because they don't have to do anything, right? I mean, if it's still owned by, if I own a road and I decide to subdivide it and say, make your road association, I don't have any liability at all. Right? If I'm a
Once you
timber.
sold off all the lots, no.
If you don't have a lot on it,
Well, this guy actually has lots, he still has land there off the road, so it's still active. So I'm not sure, it doesn't make sense to me that he shouldn't, that company shouldn't have some liability with regard to taking care of the
Well, if you own a
road.
property that gets benefited by it,
Right.
he gets an assessment, and you can include the cost of insurance in the assessment.
Right, same as everybody else, but
Yeah.
it's,
so he's not treated any different than anybody else, even if he owns the road. Yes, that's true.
and he has no liability.
He doesn't.
Other than the fact that the same liability that everybody
Yeah,
else has
yeah,
on the
same
road,
liability
sorry.
everyone else.
Yeah.
But an owner of the road who actually has title to the road, but a road association maintains it, and if I were representing the person who was injured, I would sue the owner, have negligently allowed an incompetent road association to negligently maintain that road. Because you want
He's retired, but that's what he is.
But you want to bring in as many insurance companies as you can to
Right.
make the pot bigger.
I have a question in the back, the lady,
Sued by a member,
by a member.
by a member, for a certain reason. So that's the limited part of it. If you get some drunk teenager that's not related to anybody who comes, tearing down there in a Camaro, you're not immune from anything.
But when you buy for the road association, $400, $1 million, that covers the officers the same as everybody else, correct?
As an owner, as a member,
As an
yeah.
owner, yeah.
Not necessarily as an officer. So if you're making decisions anywhere other than at your annual meeting on what to do with the road, how to spend the money, who to hire as a contractor, et cetera, you're a little bit exposed for making a bad decision as an officer. So that's the DNO insurance covers. If you make a really bad decision that wasn't in the best interest of everybody,
But if you're hiring a contractor, it's just covered by his liability, it should go back against the company, right? If they make a mistake.
it trickles down to them eventually, yeah.
But you can also be liable for negligently hiring a bad contractor.
In all honesty, here's what insurance is going to pay for 99% of the time, because you're not going to do a bad job. You're not going to set a trap. What it's going to pay for is the lawyer you have to hire in order to get out of the stupid suit that came up with it.